Yo, wala pa ba? Yo. Kamusta kayong lahat mga kababayan ko? Ito pa rin ang inyong Lolo Ray, no? Para sa isa namang edisyon ng ah, in layman's terms, ano? Kung saan sinusubukan nating basahin ang batas at sinusubukan nating ipaliwanag ng konti sa Tagalog, sa lingwaheng Filipino, ano? So ito po ay pagpapatuloy ng civil procedure. Ito po ang rules of court, civil procedure, ha? So, nagtapos po tayo doon sa Rule 40. Naririto na po tayo sa Rule 41. Appeal from the Regional Trial Courts. Sabi po rito, Section 1, ano-ano ba mga subject of an appeal? An appeal daw may be taken. Ingay. Wait lang. Yon. Okay. An appeal daw may be taken from a judgment or final order that completely disposes of the case or of a particular matter therein when declared by these rules to be appealable. Okay? So, malinaw po yun. Ang appeal daw, pwede lamang kapag meron ng judgment or final order na tinatapos niya na yung kaso. Okay? No appeal may be taken from, number 1, an order denying a petition for relief or any similar motion seeking relief from judgment. An interlocutory order, number 2. Bawal daw mag-apila. Wala doon. Number 3, an order disallowing or dismissing an appeal. Hindi ka raw pwedeng mag-appeal doon. Number 4, an order denying a motion to set aside the judgment by consent, confession, or compromise on the ground of fraud, mistake, or duress, or any other ground vitiating consent. Number 5, an order for execution. Di ka raw pwede mag-appeal doon. Number 6, a judgment or final order for or against one or more of several parties or in separate claims, counterclaims, cross-claims, and third-party complaints while the main case is pending unless the court allows an appeal therefrom. And number 7, an order dismissing an action without prejudice. Ibig sabihin nun, naglabas na ng order ang korte na dinidismiss niya na yung isang action without prejudice. Di mo na ito ibig yata sabihin nito, hindi mo na pwedeng i-file ulit. Okay? In any of the foregoing circumstances, the aggrieved party may file an appropriate special civil action as provided in Rule 65. Okay? So, sa mga ganitong pagkakataon daw na hindi ka pwede mag-appeal, ang pwede mo raw gamitin ay yung Rule 65. Usually, mga abogado lang po yung nakakaalam niyan. Parang certiorari in Rule 65, yun yata yan. Okay. Punta naman tayo Section 2, Modes of Appeal. Ano bawa? Yan, Modes of Appeal. An ordinary appeal, letter A pala. An ordinary appeal. The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its original jurisdiction shall be taken by filing a notice of appeal with the court which render the judgment or final order appealed from and serving a copy thereof upon the adverse party. So, kung napapansin nyo, kailangan bibigyan mo lagi ng kopya yung kabilang partidos, ha? No record on appeal shall be required except in special proceedings and other cases of multiple or separate appeals where law and these rules so require. In such cases, the record on appeal shall be filed and served in like manner. Okay. Letter B, petition for review. Sabi rito, yung una pinag-usapan yung ordinaryong pag-appeal. Ito naman yung petition for review. Paano nga ba itong petition for review? The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its appellate jurisdiction shall be by petition for review in accordance with Rule 42. Okay? So, yun ang gagamitin nyo. Okay? So, kunwari, tayong mga ordinaryong tao, merong naipaliwanag sa ating abogado, pwede nating i-check, okay, ito yung ginagamit niyang uri ng appeal, yung petition for review under in accordance with Rule 42. Yun. Letter C, appeal by certiorari. May nabanggit po tayong certiorari, dalawa po yun. Magkaiba yung rule certiorari on Rule 45 and certiorari on Rule 65. Pero basahin natin yung appeal by certiorari niya na ito. In all cases daw where only questions of law are raised or involved, the appeal shall be to the Supreme Court by petition for review on certiorari in accordance with Rule 45. So kung ang ina-appeal mo na lamang dito ay yung questions of law, mga katanungan tungkol sa batas. Section 3 ng Rule 31. Tama ba ako? Period of ordinary appeal. The appeal shall be taken within 15 days from notice of the judgment or final order appealed from. Where a record on appeal is required, the appellant shall file a notice of appeal and the record on appeal within 30 days from notice of the judgment or final order. Nabanggit natin to kanina dun sa Rule 40. May provision na ganito. Sabi pa, the period of appeal shall be interrupted by a timely motion for new trial or reconsideration. No motion for extension of time to file a motion for new trial or reconsideration shall be allowed. So, hindi na raw papayagan ng korte. Pag lumagpas ka, hindi ka na raw pwede mag-motion ng extension of time to file a motion for new trial. Bawal daw yun. Bawal daw yun. Alinsunod sa rules. Magtungo naman tayo sa Section 4, Appellate Court, Docket, and Other Lawful Fees. Ibig sabihin na appellate court, nakatataas na korte. Sabi rito, within the period for taking an appeal, the appellant shall pay to the clerk of court which rendered the judgment or final order appealed from the full amount of the appellate court docket and other lawful fees. Proof of payment of said fee shall be transmitted to the appellate court together with the original record or the record on appeal. So kung saan kang korte nag-aapila, ay kung saan kang korte nag-file ng iyong notice of appeal, para umakyat ka sa mas mataas na korte, magbabayad ka ron sa clerk of court nun ng corresponding docket fees. Tapos siya na, proof of payment mo, siya na magtatransmit dun sa appellate court. Section 5, Notice of Appeal. The notice of appeal shall indicate the parties to the appeal. Siyempre, ito yung binibigay mo yata sa korte ito ng isang abogado. Notice of Appeal. The notice of appeal shall indicate the parties to the appeal, specify the judgment or final order or part thereof appealed from, specify the court to which the appeal is being taken, and state the material dates showing the timeliness of the appeal. Sabihin mo yung mga date para maipakita mo na nag-a-appeal ka within the specified period. Section 6, Record on Appeal. Form and contents thereof. Okay, the full names of all the parties to the proceedings shall be stated in the caption of the record on appeal, and it shall include the judgment or final order from which the appeal is taken, and in chronological order, copies of only such pleadings, petitions, motions, and all interlocutory orders as are related to the appeal judgment or final order for the proper handling of the issue involved, para daw mas maintindihan sa taas, sa mas mataas na hukuman, together with such data as will show that the appeal was perfected on time. If an issue of fact is to be raised on appeal, the record on appeal shall include by reference all the evidence, testimonial, and documentary of the issue involved. The reference shall specify the documentary evidence by the exhibit numbers or letters by which it was identified when admitted or offered at the hearing, and the testimonial evidence by the names of the corresponding witnesses. If the whole testimonial and documentary evidence is to be included, a statement to that effect will be sufficient without mentioning the names of the witnesses or the numbers or letters of exhibits. Every record daw on appeal exceeding 20 pages. Every record daw on appeal exceeding 20 pages must contain a subject index. Linaw yun, ha? Section 7, Approval of Record on Appeal. Upon the filing of the record on appeal for approval, and if no objection is filed by the appellee within 5 days from receipt of a copy thereof, the trial court may approve it as presented or upon its own motion, or at the instance of the appellee, may direct its amendment by the inclusion of any omitted matters which are deemed essential to the determination of the issue of law or fact involved in the appeal. Sabi niya, if the trial court orders the amendment of the record, the appellant, yung nag-aapila, within the time limited in the order or such extension thereof as may be granted, or if no time is fixed by the order, within 10 days daw from receipt thereof. I-redraft mo yun. Shall redraft the record by including therein in their proper chronological sequence, tamang pagkakasunod-sunod, such additional matters as the court may have directed him to incorporate, and shall thereupon submit the redrafted record for approval upon notice to the appellee in like manner as the original draft. Section 8. Joint record on appeal. Where both parties are appellants, they may file a joint record on appeal within the time fixed by Section 3 of this rule or that fixed by the court. Pwede raw umapila. Yung dalawa, magkalaban tayo. Pareho tayong aapila. Pwede tayo mag-joint record on appeal. Section 9. Perfection of appeal. Effect thereof. Ano nga ba? Ang epekto. A party's appeal by notice of appeal is deemed perfected as to him upon the filing of the notice of appeal in due time. So usually mga abogado yan, magpapasa yan ng notice of appeal sa kayo nakasaad sa appeal niya sa korte, papasa po yan sa takdang oras. A party's appeal by record on appeal is deemed perfected as to him with respect to the subject matter thereof upon the approval of the record on appeal filed in due time. O gano'n naman doon na perfect yung record on appeal. In appeals by notice of appeal, the court loses jurisdiction over the case upon the perfection of the appeals. Okay, live na naman tayo at i-resume lang natin. Medyo naputol tayo ng konti, ano? Medyo tayo nagkaroon ng technical problem. Wow, technical problem. Okay, so mabalik tayo. Nasaan ako? Okay. Ulitin ko na lang basahin. Section 9. Perfection of appeal. Sabi rito, yung party's appeal by notice of appeal is deemed perfected as to him upon the filing of the notice of appeal in due time. Sabi niya pa rito, wait lang ha. Sabi niya pa, a party's appeal by record, ito yung record on appeal, is deemed perfected as to him with respect to the subject matter thereof upon the approval of the record on appeal filed in due time. Sa mga apila daw by notice of appeal, pagka ang ginagamit mo ay notice of appeal, the court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. Excuse me po. In appeals by record on appeal, the court loses jurisdiction only over the subject matter. Yun lang ang nawawalan siya ng jurisdiction. Yung subject matter, hindi yung buong case. Upon the approval of the records on appeal filed in due time and the expiration of the appeal of the other parties. In either case, prior to the transmittal of the original record or the record on appeal, the court may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, approve compromises, permit appeals of indigent litigants, or order execution pending appeal in accordance with Section 2 of Rule 39 and allow withdrawal of appeal. So ano naman daw yung duty ng clerk of court ng nakabababang hukuman upon perfection of appeal? Within 30 days daw, after perfection of all appeals in accordance with the preceding section, it shall be the duty of the clerk of court of the lower court to, ito yung mga yun. Letter A, to verify the correctness of the original record or the record on appeal as the case may be, aid to make certification of its correctness. Letter B, to verify the completeness of the records that will be transmitted to the appellate court. C, if found to be incomplete, to take such measures as may be required to complete the records, availing of the authority that he or the court may exercise for this purpose. And letter D, to transmit the records to the appellate court. O yung clerk of court po kasi yan nagtatransmit ng records to the appellate court. If the efforts to complete the records fail, he shall indicate his letter of transmittal, the exhibits or transcripts not included in the records being transmitted to the appellate court, the reasons for their non-transmittal. So habang pinapasa niya sa nakatataas na hukuman ito, isasaad niya rin doon yung mga reasons for their non-transmittal and the steps taken or that could be taken to have them available. The clerk of court shall furnish the parties with copies of his letter of transmittal of the records to the appellate court. Section 11, transcript. Upon the perfection of the appeal, the clerk shall immediately direct the stenographers. Yan, meron pa mga stenographers kasi ang korte. So yung mga stenographers concerned daw, idedirekta yan to attach to the record of the case 5 copies of the transcripts of the testimonial evidence referred to in the record on appeal. The stenographers concerned shall transcribe such testimonial evidence and shall prepare and affix to their transcripts an index containing the names of the witnesses and the pages wherein their testimonies are found, at yung isang listahan daw ng mga exhibits and the pages wherein each of them appears to have been offered and admitted or rejected by the trial court. The transcripts shall be transmitted to the clerk of the trial court, who shall thereupon arrange the same, ayusin niya yan, in the order in which the witnesses testified at the trial. Nakasaad kasi sa transcripts kadalasan yung mga testimonya ng mga witness, and shall cause the pages to be numbered consecutively. Section 12, transmittal. The clerk of the trial court shall transmit to the appellate court the original record of the approved record on appeal within 30 days from the perfection of the appeal, together with the proof of payment of the appellate court docket and other lawful fees, a certified true copy of the minutes of the proceedings, order of approval, the certificate of correctness, the original documentary evidence referred to therein, and the original, yung original daw, at 3 kopya ng mga transcripts. Copies of the transcripts or certified true copies of the documentary evidence shall remain in the lower court for the examination of the parties. So, kailangan may mananatili pa ring transcript doon sa lower courts para pwedeng pumunta yung mga partidos doon at i-examine nila yung mga kaganapan doon, yung mga nakasaad doon sa transcripts. Section 13. Dismissal of appeal. Prior to the transmittal of the original record or the record on appeal to the appellate court, the trial court may, motu proprio or on motion. Ibig sabihin ng motu proprio, yung sariling inisyatiba ng korte, or on motion, may partido na nag-file ng motion, pwede nilang i-dismiss yung appeal daw for having been taken out of time or non-payment of the docket and other lawful fees within the reglementary period. Yung period na itinakda ng batas na hanggang doon ka lamang pwede mag-file ng iyong apela. So yun po ang buong Rule 41. Napakahaba po, ano? Isang rule lang. Napakahaba niya. Rule 42. Petition for review from the regional trial courts to the Court of Appeals. Section 1. How appeal taken. Time for filing. Ayan, yun yung pag-usapan daw dito. Paano nag-aapila at time for filing. Ang isang partido raw, desiring to appeal from a decision of the regional trial court rendered in the exercise of its appellate jurisdiction, may file a verified petition for review with the Court of Appeals, paying at the same time to the clerk of said court the corresponding docket and other lawful fees, depositing the amount of 500 pesos for costs. Di ko lang alam kung ganito pa rin ngayon. And furnishing the regional trial court and the adverse party with a copy of the petition. So, magbabayad ka ng fee, tapos ipa-furnish mo ng copy ng decisions, bibigyan mo ng copy ng decision yung kabilang partidos. Yun ang ibig sabihin dito. The petition shall be filed and served within 15 days from notice of the decision sought to be reviewed or of the denial of petitioner's motion for new trial or reconsideration filed in due time after judgment. Upon proper motion and the payment of the full amount of the docket and other lawful fees and the deposit for cost before the expiration of the reglementary period, bago expire, nagawa mo na lahat ng mga yon, yung Court of Appeals daw may grant an additional period of 15 days only within which to file the petition for review. O pwede kang pagkalooban o i-grant ng Court of Appeals na mag-file ka ng petition for review. Pwede kanyang bigyan ng additional 15 days para gawin yon. No further extension shall be granted except for the most compelling reason and in no case to exceed 15 days. So, hindi na raw pwedeng magbigay ng extension unless sobrang compelling, sobrang makatotohanan, sobrang kapanipaniwala, at sobrang karapat dapat bigyan ka ng extension at bibigyan ka ulit ng 15 days. Pero wala nang pwedeng idagdag pa ron. Section 2, Form and Contents. The petition shall be filed in 7 legible copies, yung mga nababasang malilinaw na kopya, with the original copy intended for the court being indicated as such by the petitioner, and shall state the full names of the parties to the case without impeding the lower courts or judges thereof, either as petitioners or respondents. So, ganun daw, bibigyan ng 7 legible copies. Gastos nito, no? With the original copy intended daw for the court being indicated as such by the petitioner, and shall, letter A, yun, doon ako nagkamali. Letter A, state the full names of the parties to the case without, di mo raw isasama yung sa kaso yung lower courts or judges. Di mo sila isasama either or respondents. B, indicate the specific material dates showing that it was filed on time. Letter C, set forth concisely a statement of the matters involved, yung mga issues raised, the specification of errors or of fact or law, or both, allegedly committed by the RTC. Ano ba yung nagawang pagkakamali, error ng Regional Trial Court, and the reasons or arguments relied upon for the allowance of the appeal. Letter D, kasama rin daw nito, accompanied daw nito, yung clearly legible duplicate originals or true copies of the judgments or final orders of both lower courts. Ang sinabi niya both lower courts, kung nanggaling ka ng MTC, nag-appeal ka sa RTC, nasa Court of Appeals ka na ngayon. So yung dalawang order, final order ng courts, yung lower courts na yon, yun ang ibig niya sabihin dito. Certified correct by the clerk of court of the Regional Trial Court, the requisite number of plain copies thereof and of the pleadings and other material portions of the record as would support the allegations of the petition. Yung the petitioner then shall also submit together with the petition of certification under oath that he has not theretofore commenced any other action involving the same issues in the Supreme Court. Hindi ka pa nag-file na kahit na anong action sa Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency. Kung meron daw man such action or proceeding, he must state the status of the same, and if he should learn that a similar action or proceeding has been filed or is pending before the Supreme Court or Court of Appeals or different divisions thereof or any other tribunal or agency, he undertakes to promptly inform the aforesaid courts and other tribunal or agency thereof within 5 days therefrom. Kasi ayaw po ng korte natin yung yung mga sangkataterbang kaso, tapos ano mong ginagawa mo? Kaso ka ng kaso. Kasi po mahalaga ang oras ng mga korte para ilaan nila sa mga may problema, di ba? Tapos kaso ka ng kaso, yun lang din pala yun. Di ba? Hindi pwedeng kaso ka ng kaso. Nakaistorbo ka sa administration ng justice. Section 3. Effect of failure to comply with requirements. Ano ba yung mga epekto pag hindi ka nag-comply sa mga requirements? Ang sabi niya, ang failure of the petitioner, yung umaapila, yung failure to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees and the deposit for costs, proof of service of the petition, and the contents of and the documents which should accompany the petition shall be sufficient o sapat na raw na ground for dismissal thereof. So, madidismiss yung apila mo, hindi ka nagbayad eh. Section 4. Action on the petition. The Court of Appeals may require the respondent to file a comment on the petition, not a motion to dismiss. So, nire-require lamang ng Court of Appeals na mag-comment yung kabilang party, yung respondent, na mag-komento siya at hindi daw ang motion finds the same to be patently without merit, prosecuted manifestly for delay, or that the questions raised therein are too insubstantial to require consideration. Pwedeng i-dismiss yan ng Court of Appeals pag walang kakwenta-kwenta, walang merito yung petition. Section 5. Contents of comment. The comment of the respondent shall be filed in 7 legible copies. Kung napansin nyo, pag mag-file ka sa Court of Appeals, puro 7 legible copies ang sinasabi. Accompanied by certified true copies of such material portions of the record referred to there together with other supporting papers, and shall, letter A, state whether or not he accepts the statement of matters involved in the petition. Okay, letter B, point out such insufficiencies or inaccuracies as he believes exist in petitioner's statement of matters involved but without repetition. Letter C, state the reasons why the petition should not be given due course. Period. A copy thereof shall be served to the petitioner. Section 6, due course. Sabi rito, if upon the filing of the comment or such other pleadings as the court may allow or require, or pagkatapos daw ng expiration, after the expiration of the period for the filing thereof without such comment or pleading having been submitted, yun daw Court of Appeals finds kung matapos ang lahat na nabanggit yun, nakahanap prima facie yung Court of Appeals, prima facie, yun pala yun, that the lower court has committed an error of fact or law that will warrant a reversal or modification of the appeal decision, it may accordingly give due course to the petition. Pag nakita niya, why, may pagkakamali nga yata ang lower court, bigyan natin ito ng due course. Section 7, elevation of record. Whenever the Court of Appeals deems it necessary, it may order the clerk of court of the regional trial court to elevate the original record of the case, including the oral and documentary evidence within 15 days from notice. So, pwedeng utusan ng Court of Appeals, yung pinanggalingan na trial court na elevate mo sa mo yung mga oral and documentary evidence within 15 days from notice. Section 8, perfection of appeal. Ano ba yung epekto ng perfection of appeal? Hindi po ito perfection ng iyong sex appeal, pero perfection po ito ng iyong apila sa nakatataas na hukuman. Letter A, upon the timely filing of a petition for review. Nabanggit natin to kanina, nag-file ka ng timely petition for review and the payment of corresponding docket and other lawful fees, the appeal is deemed perfected as to the petitioner. So kung ako, natalo ako sa trial court, aapila ako. So nag-file ako ng petition for review ng nasa takdang oras at nagbayad ako ng corresponding docket fees and other lawful fees. Ibig sabihin nun, perfected na yung aking apila. The regional trial court loses jurisdiction over the case upon the perfection of the appeals filed in due time the expiration of the time to appeal of the other parties. So tandaan po natin, nabanggit kanina, notice of appeal, nawawala ng jurisdiction sa buong kaso ang trial court. Doon naman po sa isa, yung record on appeal, nawawalan lang siya ng jurisdiction sa subject matter of the case. Sabi rito, however, before the Court of Appeals gives due course to the petition, the regional trial court may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, approve compromises, permit appeal of indicted litigants, order execution pending appeal in accordance with Section 2 of Rule 39, and allow withdrawal of the appeal. Letter B. Except in civil cases decided under the rule on summary procedure, the appeal shall stay the judgment or final order unless the Court of Appeals, the law, or these rules shall provide otherwise. So, punta naman tayo sa Section 9, ang huling section ng Rule 42. Submission for decision. Kapag daw yung similar din to do sa submitted for decision. Okay, kumbaga binigyan ng due course ng appellate court. The Court of Appeals daw may set the case for oral argument or require the parties to submit memoranda. Pwede kayo mag-oral argument, mag-set siya ng date, or i-require niya lang yung partido na mag-submit ng kanilang mga memoranda within a period of 15 days from notice. The case shall be deemed submitted for decision upon the filing of the last pleading or memorandum required by these rules or by the court itself. Okay? Magtungo naman tayo sa Rule 43. Sisikapin natin tapusin yung Rule 41 hanggang 50. Pero 30 minutes na tayo mahigit. Rule 43 pa lang tayo. Ganon kahaba aralin ang batas. At sa mga law students po, sa mga abogado, hindi lang ganyan ang aral nila. Tayo binabasa lang natin eh. Tapos sinusubukan lang natin paliwanag ng konti, di ba? Punta naman tayo sa Rule 43. Narito pa rin po tayo sa Rule 43 ng Civil Procedure Rules of Court. Appeals from the Court of Tax Appeals and Quasi-Judicial Agencies to the Court of Appeals. Ito tayo yung mga apila na manggagaling sa Court of Tax Appeals and Quasi-Judicial Agencies to the Court of Appeals. Galing ng Court of Tax Appeals, aapila sa CA. Galing ng Quasi-Judicial Agencies, mga ahensya ng gobyerno, pupunta ng CA. Paano naman to? Section 1, Scope. This rule shall apply to appeals from judgments or final orders of the Court of Tax Appeals and from awards, judgments, final orders, or resolutions of or authorized by any quasi-judicial agency in the exercise of its quasi-judicial functions. Among these agencies, ano ba yung mga nag-exercise ng quasi o sabihin na natin parang judicial, pero hindi siya judicial functions, pero parang judicial. Ano-ano ba ito mga to? Ito yung Civil Service Commission, Central Board of Assessment Appeals, Securities and Exchange Commission, SEC, Office of the President, Land Registration Authority, Social Security Commission, Civil Aeronautics Board, Bureau of Patents, Trademarks and Technology Transfer, National Electrification Administration, Energy Regulatory Board, National Telecommunications Commission, NTC, Department of Agrarian Reform under RA 6657, Government Service Insurance System, GSIS po yan, Employees Compensation Commission, Agricultural Invention Board, Insurance Commission, Philippine Atomic Energy Commission, Board of Investments, Construction Industry Arbitration Commission, and voluntary arbitrators authorized by law. Voluntary arbitrators, ito yung mga voluntaryong tagapamagitan na binigyan ng authority ng batas. Ito yung mga ito yung mga desisyon dyan, mga ipagtatalo-talo dyan. Okay, apila ka sa CA. Okay? Section 2, cases not covered. This rule shall not apply to judgments or final orders issued under the Labor Code of the Philippines. So, pag nanggaling pala sa Labor Code, hindi mag-a-apply yung, hindi siya covered. Section 3, where to appeal. An appeal under this rule may be taken to the Court of Appeals within the period and in the manner herein provided, whether the appeal involves questions of fact, law, or mixed questions of fact and law. So, pwede na tayong umapila dyan. Kapag tayo ay nag-appeal under yung certiorari under Rule 45, yun po ay isang uri ng pag-appeal. Questions of law lamang, yun yung sinabi. Pero sa pagkakataong ito, kahit questions of fact daw, yung mga nanggaling sa quasi-judicial bodies, kahit questions of fact daw, kahit questions of law, or mixed, pwede kang mag-appeal sa Court of Appeals. Section 4, period of appeal. The appeal shall be taken within 15 days from notice of the award, judgment, final order, or resolution, or from the date of its last publication if publication is required by law for its effectivity, or of the denial of petitioner's motion for new trial or reconsideration duly filed in accordance with the governing law of the court or agency a quo. Only one nag-iisang motion for reconsideration daw lamang shall be allowed. Upon proper motion, the payment of the full amount of the docket fee before the expiration of the reglementary period, the Court of Appeals may grant an additional period of 15 days only within which to file the petition for review. No further extension shall be granted except for the most compelling reason and in no case to exceed 15 days. Di nalalagpas pa yan. 15 days lang talaga. Hanggang doon lang. Section 5, how appeal taken. Paano nga ba? How appeal taken. Appeal shall be taken by filing a verified petition for review in 7 legible copies with the Court of Appeals. So, ganun din sa kanina, 7 legible copies. Pero ito nga is appeal from quasi-judicial and agencies and yung Court of Tax Appeals papunta ng CA. Ganun din, magpa-file ka ng verified petition for review in 7, mahalaga po ang number 7, legible copies with the Court of Appeals with proof of service of a copy thereof. May pruweba ka na pinadala mo ng kopya yung kalaban mong partido and on the court or agency a quo, o doon sa ahensya kung saan ka man nakikipagtalo. The original copy of the petition intended for the Court of Appeals shall be indicated as such by the petitioner. Okay. Upon the filing daw of the petition, the petitioner shall pay to the clerk of the Court of Appeals the docketing and other lawful fees and deposit the sum of 500 pesos for costs. Exemption from payment of docketing and other lawful fees and the deposit for costs may be granted by the Court of Appeals upon a verified motion setting forth valid grounds therefore. If the Court of Appeals denies the motion, the petitioner shall pay the docketing and other lawful fees and deposit for costs within 15 days from notice of denial. Section 6. Contents of the petition. Ano yung nilalaman ng petition? Ganun pa rin yata. The petition for review shall A. State the full names of the parties to the case without impeding the court or agencies either as petitioners or respondents. Ibig sabihin, hindi mo sasali. Kanina, hindi mo rin isasali yung mga judge ng lower court. Hindi mo naman sila kalaban. Ito naman, hindi mo naman isasali yung ahensya. Hindi, full names of the parties in the case, hindi mo nga lang isasali as either petitioners or respondents. Yung ahensya kung saan ka nakikipagtalo. Letter B. Contain a concise statement of the facts and issues involved and the grounds relied upon for review. Letter C. Be accompanied by a clearly legible duplicate, original, or certified true copy of the award, judgment, final order, or resolution appealed from, together with certified true copies of such material portions of the record referred to therein and other supporting papers. And letter D. Contain a sworn certification against forum shopping as provided in the last paragraph of Section 2, Rule 42. The petition shall state the specific material dates showing that it was filed within the period fixed herein. Tingnan nga natin ibig sabihin ng impleaded para lang makasiguro tayo. Without impleading yun lagi yung sinasabi impleaded. To sue in court of law, to bring into action. So without impleading, without suing, ibig sabihin, tama nga yung ibig sabihin, without suing yung lower court, yung trial court judges at yung ahensya. Yun ang ibig sabihin. Okay, babalik tayo. Section 7. Effect of failure to comply with requirements. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the dockets and other lawful fees, ganun din, shall be a ground for dismissal na rin. Bayad ka ng docket fees. File ka ng notice ng petition for review sa takdang oras. Section 8. Action on the petition. The Court of Appeals may require the respondent to file a comment on the petition, not a motion to dismiss. Ganun din, magpa-file ka ng comment mo. Hindi ka magpa-file ng motion to dismiss within 10 days from notice or dismiss the petition. Ganun din, i-dismiss niya rin yung petition when the Court of Appeal finds out na walang kakwenta-kwenta, walang merito ang iyong appeal. Section 9, contents of the comment. The comment shall be filed within 10 days from notice in 7 legible copies. Paulit-ulit yung 7 legible copies na yan. At sasamahan pa ng clearly legible certified true copies of such material portions of the record that referred to therein together with other supporting papers. Yan, kanina pa natin binabasa yan. Pero nakalagay din siya sa iba't ibang mga sections ng mga rules. The comment shall, letter A, point out insufficiencies or inaccuracies in petitioner's statement of facts and issues, and letter B, state the reasons why the petition should be denied or dismissed. A copy thereof shall be served on the petitioner and proof of such service shall be filed with the Court of Appeals. Section 10, mga kababayan, due course. Kapag daw, if upon the filing of the comment, nagkomento na yung kalaban mo sa kasong kung saan ka umapila. If upon the filing of the comment or such other pleadings or documents as may be required or allowed by the Court of Appeals, or upon the expiration of the period for the filing thereof, and on the records, the Court of Appeal finds prima facie that the court or agency concerned has committed errors of fact or law that would warrant reversal or modification of the award, judgment, final order, or resolution sought to be reviewed, yun daw korte may give due course to the petition. Bibigyan niya yan ng due course. Otherwise, it shall dismiss the same. The findings of fact of the court or agency concerned when supported by substantial evidence shall be binding on the Court of Appeals. Okay. Section 11. Nakakangala ito. Wow. Nakitest ko ngayon pa ako. Section 11. Transmittal of record. Sabi rito, within 15 days from notice that the petition has been given due course, the Court of Appeals may require the court or agency concerned to transmit the original or a legible certified true copy of the entire record of the proceeding under review. The record to be transmitted may be abridged by agreement of all parties to the proceeding. The Court of Appeals may require or permit subsequent correction of or addition to the record. Section 12. Anong epekto raw ng appeal? The appeal shall not stay the award, judgment, final order, or resolution sought to be reviewed unless Court of Appeals shall direct otherwise upon such terms as it may deem just. Section 13. Submission for decision. If the petition daw is given due course, the Court of Appeals may set the case for oral argument. Ganun na naman, nabanggit na kanina to. Or pwede sila mag-require ng memoranda to be submitted within the period given, which is 15 days. The case shall 15 days from notice. The case shall be deemed submitted for last decision upon the filing of the last pleading or memorandum required by these rules or by Court of Appeals. So ano naman, magtungo naman tayo sa procedure in Court of Appeals. Ayan, usually kahit law student, minsan hindi na alam to kasi Court of Appeals. Pero alamin natin, sige, mga ordinaryong tao tayo na nag-aaral ng batas. Charot. Basahin lang natin. Ordinary appealed cases. Section 1, Title of Cases. In all cases appealed to the Court of Appeals, under Rule 41, the title of the case shall remain as it was in the court of origin. But the party appealing the case shall be further referred to as the appellant. O yung umaapila, appellant. And the adverse party, yung kalaban niya, yun yung appellee. Nalito ako doon tama. Appellant yung umaapila, appellee yung adverse party. Section 2, Counsel and Guardians. Sabi rito, the counsel and guardians ad litem of the parties in the court of origin shall be respectively considered as their counsel and guardians ad litem in Court of Appeals. When others appear or are appointed, notice thereof shall be served immediately on the adverse party and filed with the court. So kapag aalis na yung abogado, magmo-motion siya to withdraw from the case. Kapag naman yung guardian, may bago ng guardian ad litem o yung guardian na appointed ng court, magbibigay din syempre ng notice sa court. Pag may bago ng abogado, notice for, ano na yan? Nalimutan ko na yung term. Basta parang ang dating niya is notice for, na siya yung mag-e-enter doon sa, mag-e-enter as counsel. Parang gano'n. Section 3, Order of Transmittal of Record. If the original record or the record on appeal is not transmitted to the Court of Appeals within 30 days after the perfection of the appeal, either party may file a motion with the trial court with notice to the other for transmittal of such record or record on appeal. Section 4, Docketing of Case. Upon receiving the original record or the record on appeal and the accompanying documents and exhibits transferred by the lower court, as well as the proof of payment of the docket and other lawful fees, yung clerk of court daw ng Court of Appeals shall docket the case and notify the parties thereof. So, parang docketing, parang ganito yan parang ililista niya lang yan doon sa listahan niya. Tapos bibigyan ng case number, yung case. Within 10 days from receipt of said notice, the appellants in appeals by record on appeal shall file with the clerk of court 7 clearly legible copies of the approved record on appeal together with the proof of service of 2 copies thereof upon the appellee. Any unauthorized alteration, omission, or addition in the approved record on appeal shall be a ground for dismissal of the appeal. Magtungo naman tayo Section 5, Completion of Record. Where the record of the docketed case is incomplete, kulang-kulang, yung clerk of court daw ng CA shall so inform the said court and recommend to it measures necessary to complete the record. It shall be the duty of said court to take appropriate action towards the completion of the record within the shortest possible time. Siyempre, kailangan kompleto yung records mo. Section 6, Dispensing with complete record. Where the completion of the record could not be accomplished within a sufficient period allotted for said purpose due to insuperable or extremely difficult causes, the court on its own motion or on motion of any of the parties may declare that the record and its accompanying transcripts and exhibits so far available are sufficient. Parang mag-motion tayo, sapat na ito. Motion to dispense with complete record. Sapat na ito. to decide the issues raised in the appeal and shall issue an order explaining the reasons for such declaration. Section 7, Appellant's Brief. Ito yung brief ng umaapila. Hindi po yung underwear ha, kundi ito, basahin ko na lang. It shall be the duty of the appellant to file with the court within 45 days from receipt of the notice of the clerk that all the evidence, oral and documentary, are attached to the record. 7 copies of his legibly typewritten, mimeographed or printed brief with proof of service of 2 copies thereof upon the appellee. Ito yung kanyang brief, ito yung kanyang paglalahad, parang ganon. Section 8, appellant's brief. Parang naulit lang. Section 7, ganun. Section 8, within 45. Basahin na rin natin. Within 45 days from receipt of the appellant's brief, yung kalaban niya, nung umaapila, yung kabilang partido, the appellee, shall file with the court 7 copies of his legibly typewritten, mimeographed, or printed brief with proof of service of 2 copies thereof upon the appellant. Section 9, Appellant's Reply Brief. O ito, yung umaapela, sinagot niya yung sagot sa kanya. Ito na yung reply brief. Within 20 days from receipt of the appellee's brief, the appellant may file a reply brief answering points in the appellee's brief not covered in his main brief. Again, ito po yung salaysay, mga dokumentong pinapasa ng bawat partido. Hindi po ito underwear. Section 10, Time of filing memoranda in special cases. In certiorari prohibition mandamus quo warranto in habeas corpus cases, the parties shall file in lieu of briefs their respective memoranda within an unextendable period of 30 days from receipt of the notice issued by the clerk that all the evidence, oral and documentary, is already attached to the record. The failure of the appellant to file his memorandum within the period, therefore, may be a ground for dismissal of the appeal. Section 11, several appellants or appellees or several counsel for each party. Marami raw umaapela, maraming sumasagot doon sa apela na yun, yung mga appellee. O kaya naman daw ay maraming abogado, daming counsel sa bawat partidos. Mga big time ito. Where there are several appellants or appellees, each counsel representing one or more but not all of them shall be served with only 1 copy of the briefs. When several counsel represents one appellant, marami siyang abogado, or appellee, copies of the brief may be served upon any of them. So, ganoon din. Kahit sino sa inyo, lahat naman kayo, abogado nito. Ito, marami siyang abogado, o kahit sino doon, pwedeng pagbigyan. Section 12, Extension of time for filing briefs. Extension of time for the filing of briefs will not be allowed, except for good and sufficient cause, and only if the motion for extension is filed before the expiration of the time sought to be extended. Ito, ano na to? Court of Appeals na ito. Mas, kumbaga, kung isa kang abogado, mas nakakasindak. Kasi malayo eh. Ang layo niya eh. Okay. Section 13, Contents of Appellant's Brief. Ano ba yung nilalaman ng appellant's brief na yan? Sabi ko, hindi yan underwear. Ano ba nilalaman yan? Ito yung mga laman yan. A subject index of the matter in the brief with the digest of the arguments and page references and a table of cases alphabetically arranged, textbooks and statutes cited with references to the pages where they are cited. So, yun may index, tapos may napakarami niyang laman. Okay, letter B, an assignment of errors intended to be urged. Ayan, siguro ilalagay ng abogado yan. Ito yung mga errors, chorba. Ito, which errors shall be separately, distinctly, and concisely stated without repetition and numbered consecutively. Assignment of errors, number 1, chorba, 2, chorba, 3, chorba. Letter C, under the heading statement of the case, ilalagay mo daw doon ang isang clear and concise statement of the nature of the action, a summary of the proceedings, ano ba yung mga nagdaang proceeding, ano ba yung mga naganap, the appeal, rulings and orders of the court, the nature of the judgment, and any other matters necessary to an understanding of the nature of the controversy with page references to the record. Pag sinulat mo yon under ganito, kunwari, exhibit ganito, titignan niya na lang. So, may exhibit niya. May page references, may O basta ganun, mali, alam nyo na yun. Letter D. Under the heading Statement of Facts, a clear and concise statement in a narrative form of the facts admitted by both parties and of those in controversy. So, lilinawin mo na. Ito yung mga inamin na namin. Ito yung in controversy. Ito yung substance of the proof relating thereto in sufficient detail to make it clearly intelligible with page references to the record para hindi na mahirapan yung mga magbabasang mahistrado. Letter E. A clear and concise statement of the issues of fact or law to be submitted to the court for its judgment. Ito po yung issue namin sa fact or law na kailangan naming ma-resolve ninyo. Kailangan mga nakaalam nito. Letter F. Under the heading argument, so doon ilalagay mo yung mga argumento mo. The appellant's arguments on each assignment of error, di ba? May inassign kang error. Ito yung mga pagkakamali. O, ito yung mga argumento ko naman sa pagkakamali. Sa bawat daw, the appellant's arguments on each assignment of error with page references to the record, ilalagay daw yun. The authorities relied upon shall be cited by the page of the report at which the case begins and the page of the report on which the citation is found. Letter G, under the heading relief, ito yung a specification of the order or judgment which the appellant seeks. Ito yung hinahangad mo na makuhang remedyo. Specification of the order or judgment which the appellant seeks. And letter H, in cases not brought up by record on appeal, the appellant's brief shall contain as an appendix, a copy of the judgment or final order appeal from. So nakalagay pa rin doon yung inaapila mong desisyon sa mas nakabababang court. Parang, ba't doon? Dito na sa side. Mas nakabababang court. Okay, section 14. Ano naman yung nilalaman ng appellee's brief? Ito yung parang sagot, kung baga. Sagot, di ba, umaapila ako. O, ikaw yung appellee. O, ito naman yung mga sagot mo. The appellee's brief shall contain in the order herein indicated the following. Letter A. A subject index of the matter in the brief with a digest of the arguments and page references and a table of cases alphabetically arranged, textbooks and statutes cited with references to the pages where they are cited. Similar din doon sa nakalagay yata to sa appellant's brief eh. B. Under the heading Statement of Facts, the appellee shall state that he accepts the statement of the ganun din. Parehas din. Yung same version, pero yung kontra mo naman doon sa kanya, pero same format. Yun lang yung nakalagay. Section 15, questions that may be raised on appeal. Ano naman yung mga questions na pwede mong i-raise on appeal? Whether or not the appellant has filed a motion for new trial in the court below, he may include in his assignment of errors any question of law or fact that has been raised in the court below and which is within the issues framed by the parties. So, basta question of law or fact, erase mo yan. Charot. Ganun ba yan? Appeal by certiorari to the Supreme Court. Rule 45 naman. Ito, hindi, iba na ito. Ang pinag-usapan na natin dito ay isang uri ng apila by certiorari to the Supreme Court naman to. Galing kasi trial court, boom, certiorari mo kasi Supreme Court. Ganun ba yun? Hindi ka manggagaling pala sa trial court nito, sorry. Basahin na nga natin para malinaw. Sabi rito, Section 1, filing of petition with the Supreme Court, the highest court of the land. Sabi rito, a party desiring to appeal by certiorari from a judgment, final order or resolution of, ito mga babanggitin ko, dito lang, inaapila mo yung mga decision, final judgment ng Court of Appeals, Sandigan Bayan, the Court of Tax Appeals, the Regional Trial Courts, kasali pala, or other courts, basta pinapayagan daw ng batas, authorized by law. So, yung party desiring to appeal yung mga nabanggit kong decision sa mga courts na yon, may file with the Supreme Court a verified petition for review on certiorari. The petition may include an application for a writ of preliminary injunction or other provisional remedies and shall raise only questions of law. At pag gagamitin mo daw itong appeal by certiorari on Rule 45, only questions of law lamang ang i-raise mo, walang questions of fact. Okay, nasa na ako. The petition may include an application for a writ of preliminary injunction. Pwede mong isali yung writ of preliminary injunction or other provisional remedies and shall raise only questions of law which must be distinctly set forth. The petitioner may seek the same provisional remedies by verified motion filed in the same action or proceeding at any time during its pendency. So, yun lang ha. Section 2. Ano ba yung oras for filing? May extension ba? Sinasabi, the petition shall be filed within 15 days from notice of the judgment or final order or resolution appealed from or of the denial of the petitioner's motion for new trial or reconsideration filed in due time after notice of the judgment. On motion duly filed and served, with full payment of the docket and other lawful fees and the deposit for costs before the expiration of the reglementary period, yun daw Supreme Court may, for justifiable reasons, grant an extension of 30 days only within which to file the petition. So sabi kanina, pag Court of Appeals, kapag ka naman ikaw ay nakapagbayad na ng lawful fees at nakapag ano ka na, at bago raw yung expiration ng reglementary period, yung Court of Appeals, sabi kanina, pwede siyang mag-extend ng 15 days para sa iyo pa at hindi na yun may extend pa muli. Pag Supreme Court naman, 30 days pa. Yan sinabi. Section 3, docket and other lawful fees at proof of service of petition. Ano ba ito? Sabi rito, unless he has theretofore done so, the petitioner shall pay the corresponding docket and other lawful fees to the clerk of court of the Supreme Court and deposit the amount of 500 pesos for costs. Sana nga ganun pa rin ngayon, ano? Yung halaga, 500 for costs at the time of the filing of the petition. Excuse me po. Proof of service of a copy thereof on the lower court concerned and on the adverse party shall be submitted together with the petition. Tungo naman tayo, Section 4, Contents of Petition. The petition shall be filed in 18 copies with the original copy intended for the court being indicated as such by the petitioner and shall A. State the full name of the appealing party as the petitioner and the adverse party as respondent without impleading the lower courts or judges thereof either as petitioners or respondents. Letter B. Wink. Indicate the material dates showing when notice of the judgment or final order or resolution subject thereof was received, when a motion for new trial or reconsideration, if any, was filed, and when notice of the denial thereof was received. Letter C. Set forth concisely a statement of the matters involved and the reasons or arguments relied on for the allowance of the petition. And letter D. Be accompanied by a clearly legible duplicate original or a certified true copy of the judgment or final order or resolution certified by the clerk of the court ACUO and the requisite number of plain copies thereof and such material portions of the record as well as material portions of the record as would support the petition. And letter E. Contain a sworn certification against forum shopping as provided in the last paragraph, Section 2, Rule 42, certification of non-forum shopping. Ibig sabihin, hindi ka nagsha-shopping ng mga forum. Yun talaga ibig sabihin nun. Hindi ka kung saan-saan nagpa-file ka ng kaso. Section 5, dismissal or denial of petition. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees, ganun din sa kanina. Deposit for costs, yung mga kailangan bayaran, proof of service of the petition, and the contents of and documents which should accompany the petition, yung mga dapat nakasaad sa petition, shall be sufficient o sapat na nabasihan para i-dismiss ng Korte Suprema yung petition. Ayan na, nakabuka ka na ako. Sabi pa rito, the Supreme Court may, on its own initiative, deny the petition on the ground that the appeal is without merit or is prosecuted manifestly for delay, nagde-delay ka lang, nagpapahaba ka lang ng problema, or that the questions raised therein are too unsubstantial to require consideration, walang kakwenta-kwentang bigyan ng pansin. Section 6, Review Discretionary. Ang sabi niya rito, yung daw review is not a matter of right, hindi yan karapatan ng bawat tao. It is discretionary daw. but of sound judicial discretion, and will be granted only when there are special and important reasons thereof. The following, while neither controlling nor fully measuring the court's discretion, indicate the character of what reasons which will be considered. Ano ba yung pwede nating i-review? Yun ang sinasabi ng higher court eh. Ano yung mga pwede bang i-review? Letter A. When the court akuo has decided a question of substance not theretofore determined by the Supreme Court, or has decided it in a way probably not in accord with law or with the applicable decisions of the Supreme Court, or dalawa lang pala sila, letter B. When the court akuo has so far departed from the accepted and usual course of judicial proceedings, or so far sanctioned such departure by a lower court as to call for an exercise of the power of supervision. Kanina ba binabanggit yung court akuo? Ano ba ang kahulugan nun? Hanapin natin. Court akuo. Yan. Ano ba? Ano ibig sabihin ito? Anong legal definition ito? The court, ang ibig sabihin ng court akuo, the court from which an appeal has been taken. Kung saan ka umapila? The appellate court. Court akuo. Diba? May mga ganun no? Parang expert tayo no? Feeling lawyer tayo no? Pero hindi. I would just like to remind everyone that you listen to lawyers. Ang consultation ba ay para sa mga abogado lamang at hindi para sa mga katulad. Yung ililinawin ko, lisensyadong abogado lamang, doon lamang kayo sumangguni. Ako po, yung mga katulad ko ay nagbabasa lamang at nagpipilit mag-share ng info sa inyo. Pero yung mga may problema po sa legal na aspeto ng inyong buhay, sasangguni lamang kayo sa mga lisensyadong abogado lamang. Okay? Bawal po yung mga abogadilyo na katulad namin, wala po kaming karapatan na magbigay ng ng legal advice. Okay. Pwede lang siguro kaming mag-share, magbasa ng mga books para sa inyong kaalaman. Bigay kami ng konting eksplanasyon na nalalaman namin. Ngunit bawal, hindi po kami pwedeng tumanggap ng bayad. Di po kami pwedeng pupunta lamang po kayo para magkonsulta sa mga lisensyadong abogado. Okay, isang paalala po yan sa lahat ha. Section 7. Pleadings and documents that may be required. Ano ba yung mga sanctions? For purposes of determining whether the petition should be dismissed or denied pursuant to Section 5 of this rule, or where the petition is given due course under Section 8 hereof, the Supreme Court may require or allow the filing of such pleadings, briefs, memoranda, or documents as it may deem necessary within such periods and under such conditions as it may consider appropriate, and impose the corresponding sanctions in case of non-filing or unauthorized filing of such pleadings and documents or non-compliance with the conditions therefore. Section 8. Due course, elevation of records. Kung daw ang petition ay ang Supreme Court ay nagdesisyon na bigyan ng due course ang iyong apela, the Supreme Court may require the elevation of the complete record of the case or specified parts thereof within 15 days from notice. Section 9. Rule applicable to both civil and criminal cases. Applicable daw itong rule na ito on both civil and criminal cases. Sabi ko kanina, civil procedure itong pinag-uusapan natin, pero ang sabi niya, applicable daw ang rule na ito sa itong rule lamang niya ito, sa civil and criminal cases. The mode of appeal prescribed in this rule shall be applicable in both civil and criminal cases, except in criminal cases where the penalty imposed is death, reclusion perpetua, or life imprisonment. Magtungo tayo sa Rule 46, Original Cases. Section 1, Title of Cases. In all cases originally filed in the Court of Appeals, the party instituting the action shall be called the petitioner, and the opposing party the respondent. Kunwari ako, kakasuhan kita. Ako yung petitioner, ikaw yung respondent. Section 2. To what actions applicable? This rule shall apply to original actions for certiorari, prohibition, mandamus, and quo warranto. So, ganito po yan. Galing tayo sa lower court. Magkalaban tayo. Sa lower court, ako yung nag-start ng petition. Kinasuhan kita. So, petitioner ako, respondent ka. Ngayon, natalo ka. Umapila ka. Ikaw na ngayon yung petitioner doon. Ako naman yung respondent doon sa nakatataas na hukuman. Para sa mas malinaw na paliwanag. Okay, except as otherwise provided, the actions for annulment of judgment shall be governed by Rule 47. Tapos, yun naman, yun yung actions daw for annulment of judgment shall be governed by Rule 47. Rule 65 naman daw ang mag-govern for certiorari, prohibition, and mandamus. At sa quo warranto naman, sikat na sikat yan, Attorney Larry Gadon, siya yung abogado laban kay former Chief Justice Sereno. Rule 66 naman ang mag-govern nitong mga rules na ito. Rules of court. Again, mahanap nyo po ito sa internet. Pwede rin po. Okay? Binabasa ko lang po siya sa internet. Section 3, Contents and Filing of Petition. Effect of non-compliance with requirements. The petition shall contain the full names and actual addresses of all the petitioners and respondents, a concise statement of the matters involved, the factual background of the case, and the grounds relied upon for the relief prayed for. In actions filed under Rule 65, ito yung certiorari using Rule 65, the petition shall further indicate, ito raw yung ilalagay doon, the material dates showing when notice of the judgment or final order or resolution subject thereof was received, comma, when a motion for new trial or consideration, if any, was filed, and when notice of the denial thereof was received. It shall be filed in 7 clearly legible copies together with proof of service thereof on the respondent with the original copy intended for the court indicated as such by the petitioner and shall be accompanied by a clearly legible duplicate original or certified true copy of the judgment, order, resolution, or ruling subject thereof, such material portions of the record as are referred to therein, and other documents relevant or pertinent thereto. The certification shall be accomplished by the proper clerk of court or by his duly authorized representative or by the proper officer of the court, tribunal, agency, or office involved or by his duly authorized representative. The other requisite number of copies of the petition shall be accompanied by clearly legible plain copies of all documents attached to the original. Ganun po siya. The petitioner shall also submit together with the petition a sworn certification that he has not theretofore commenced any other action involving the same issues in the Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency. If there is such other action or proceeding, he must state the status of the same, and if he should thereafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency, he undertakes to promptly inform, kailangan mo lang i-inform, the aforesaid courts and other tribunal or agency thereof within 5 days therefrom. So kung may pending kang chorva, kung may pending kang kaso sa iba't ibang mga nabanggit na iyon, lagi ang sinasabi sa rules of court within 5 days. Kailangan i-undertake mong i-inform yung korte within 5 days therefrom. The petitioner shall pay the corresponding docket and other lawful fees to the clerk of court and deposit the amount of 500 pesos. Sana'y ganun pa rin. For costs, sana bumaba pa, for costs at the time of the filing of the petition. Failure of the petitioner to comply any of the requirements shall be sufficient ground for the dismissal of the petition. Section 4. Jurisdiction over person of respondent. How acquired? Paano rin nakukuha yung jurisdiction do sa respondent? The court shall acquire jurisdiction of the person of the respondent by the service on him of its order or resolution indicating its initial action on the petition or by his voluntary submission to such jurisdiction. Section 5. Ano ba yung pinag-usapan natin? Section 5 na tayo ng real cases. Section 5 tayo, Section 4. So, original cases na ang pinag-uusapan natin dito. Kapag daw yung defendant daw, ganong pamamaraan nakukuha yung jurisdiction sa kanya. Magtungo naman tayo sa Section 5, action by the court. The court may dismiss the petition outright with specific reasons for such dismissal or require the respondent to file a comment or the same within 10 days from notice. Only pleadings required by the court shall be allowed. All other pleadings and papers may be filed only with leave of court. So, meron lamang mga pleadings na papayagan ng korte. Yung ibang pleadings or papers, kagaya sa mga nabanggit natin sa mga nagdaan nating episode, may be filed only with leave of court. Section 3, determination of factual issues. Whenever necessary to resolve factual issues, the court itself may conduct hearings thereon or delegate the reception of the evidence on such issue to any of its members or to an appropriate court, agency, or office. Section 7, effect of failure to file comment. When no comment is filed by any of the respondents, the case may be decided on the basis of the record without prejudice to any disciplinary action which the court may take against the disobedient party. Sana malapit nang matapos. Dami pa eh. Rule 47, annulment of judgments of final orders and resolutions. Section 1, yung coverage. Ito daw, rule na ito shall govern the annulment by the Court of Appeals of judgment or final orders and resolutions in civil actions, take note, in civil actions of regional trial courts for which the ordinary remedies of new trial, appeal, petition for relief, or other appropriate remedies are no longer available through no fault of the petitioner. So, pwede raw gamitin yung annulment of judgment or final orders pag hindi na available yung mga remedyong nabanggit sa dahilan na hindi naman pagkasalanan ng petitioner. Section 2, grounds for annulment. Ano ba yung mga grounds for annulment of judgment? The annulment may be based only on the grounds of extrinsic fraud and lack of jurisdiction. So, para mag-petition tayo for annulment of judgment, ang pwede lamang nating gawing grounds ay extrinsic fraud. Paano ba ipapaliwanag ang extrinsic fraud? Fraud o panloloko sa extrinsic. Charot. Basta alam nyo na yon. And lack o kawalan ng jurisdiction. Extrinsic fraud shall not be a valid ground if it was availed of or could have been availed of in a motion for new trial or petition for relief. Kung nagamit na siya sa motion for new trial or petition for relief, di mo siya orders or resolutions. Okay. Section 3, period of filing. If based on extrinsic fraud, the action must be filed. Ulitin natin na extrinsic fraud at ang lack of jurisdiction, yan lang ang dalawang ground para sa annulment of judgment. Ang period of filing niya, kung gagamitin mo ang extrinsic fraud, the action must be filed within 4 years from its discovery. Pag na-discover mo na, may extrinsic fraud, 4 years, within 4 years pwede. And if within 4 years from the time na ma-discover mo siya. And if base naman sa kawalan ng jurisdiction, before it is barred by laches or estopel. Section 4, filing and contents of petition. The action shall be commenced by filing a verified petition alleging therein with particularity the facts and the law relied upon for annulment as well as those supporting the petitioner's good and substantial cause of action or defense as the case may be. The petition shall be filed in 7. Pito na naman. Bakit ba ang hilig nyo sa pito? Ba't ayaw nyo ng 8? Charot. 7 clearly legible copies together with sufficient copies corresponding to the number of respondents. A certified true copy of the judgment or final order or resolution shall be attached to the original copy of the petition intended for the court and indicated as such by the petitioner. Yun din daw, petitioner shall also submit together with the petition affidavits of witnesses or documents supporting the cause of action or defense and a sworn certification that he has not theretofore commenced any other action involving the same issues in the Supreme Court, Court of Appeals, or different divisions thereof, or any other tribunal or agency if there is such other action or proceeding. Kung meron man daw, kailangan niyang state, nabanggit na natin to so many times, he must state the same, and if he should thereafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals, or different divisions thereof, or any tribunal or agency. Sandali lamang. Bakit? Tatapusin ko lang to, tatawagan kita. Ayun, may nagtatanong lang kung naka-live daw ba ako. Mga jowa. Siya na, ayun daw, kung meron man daw mga naka-file, nakabinbin, nakapending sa ibang mga agency or court, he undertakes to promptly inform the aforesaid courts and other tribunal or agency thereof within 5 days therefrom. Section 5. Action by the court. Should the court find no substantial merit in the petition, pwede naman daw i-dismiss. Should prima facie merit be found in the petition, the same shall be given due course and summons shall be served on the respondent. Section 6. Procedure. The procedure in ordinary civil cases shall be observed. Should trial be necessary, the reception of the evidence may be referred to a member of the court or a judge of a regional trial court. Section 7. Effect of judgment. A judgment of annulment shall set aside the questioned judgment or final order or resolution and render the same null and void without prejudice to the original action being refiled in the proper court. Yun nga lamang daw, however, where the judgment or final order or resolution is set aside on the ground of extrinsic fraud, the court may on motion order the trial court to try the case as if a timely motion for new trial has been granted. So kapag daw ang desisyon, ang basihan ng annulment of judgment o yung linawin natin, may judgment na nagpetition yung isang partido for annulment of judgment. Nag-ground ito ngayon dahil sa extrinsic fraud. Pag extrinsic fraud daw ang dahilan, the trial court daw may order a new trial. May panibagong paglilitis. It's as if a timely motion for new trial has been granted. It's as if a timely motion for new trial has been granted. Yan po ibig sabihin. Section 8, suspension prescriptive period. The prescriptive period for the refiling of the aforesaid original action shall be deemed suspended from the filing of such original action until the finality of the judgment or annulment. However, the prescriptive period shall not be suspended where the extrinsic fraud is attributable to the plaintiff in the original action. Section 9. Relief available. The judgment of annulment may include the award of damages, attorney's fees, and other relief. If the questioned judgment or final order or resolution had already been executed, the court may issue such orders of restitution or other relief as justice and equity may warrant under circumstances. Section 10. Annulment of judgments or final orders of municipal trial courts. So, mga MTC, lower courts. An action to annul a judgment or final order of a municipal trial court shall be filed in the regional trial court daw, having jurisdiction over the former. So, hindi ka pala sa MTC magpa-file ng motion for annulment of judgment sa RTC. It shall be treated as an ordinary civil action, and sections 2, 3, 4, 7, 8, and 9 of this rule shall be applicable thereto. Nakakapagod. Napagod basahin ito. Okay. Hopefully, konti na lang. Rule 48, Preliminary Conference. Sabi rito, preliminary conference at any time during the pendency of the case, the court may call the parties and their counsel to a preliminary conference. Bakit nga ba at any time daw during the pendency of the case, yung korte pwede magpatawag ng preliminary conference? A. To consider the possibility of an amicable settlement except when the case is not allowed by law to be compromised. Letter B. To define, simplify, and clarify the issues for determination. Letter C. To formulate stipulations of facts and admissions of documentary exhibits, limit the number of witnesses to be presented in cases falling within the original jurisdiction of the court or those within its appellate jurisdiction where a motion for new trial is granted on the ground of newly discovered evidence. And letter D, to take up such other matters which may aid the court in the prompt disposition of the case. Sa mas mabilis at matiwasay na disposition ng case. Section 2, Record of the Conference. The proceedings at such conference shall be recorded, and upon the conclusion thereof, a resolution shall be issued embodying all the actions taken therein, the stipulations and admissions made, and the issues defined. Okay. Magkaiba po ito sa pre-trial. Pero pre-trial ginagawa bago ka magsimula ng paglilitis. Ito, sabi ng court, sabi rito, at any time daw pwedeng yung court magpatawag nito para, teka lang, naguguluhan ako. Naguguluhan si judge. Linawin nyo yan. Section 3, binding effect of the results of the conference. Subject to such modifications which may be made to prevent manifest injustice, the resolution in the preceding section shall control the subsequent proceedings in the case unless, within 5 days from notice thereof, any party shall satisfactorily show valid cause why the same should not be followed. Magtungo tayo sa Rule 49, Oral Argument. Section 1, when allowed. Kailan nga lang ba pinapayagan to? Hindi na madalang na ito eh. Puro judicial affidavit na eh. At its own instance or upon motion of a party, the court may hear the parties in oral argument on the merits of a case or on any material incident in connection therewith. The oral argument shall be limited to such matters as the court may specify in its order or resolution. Section 2, Conduct of oral argument. Unless authorized by the court, only one counsel may argue for a party. The duration allowed for each party, the sequence of the argument. Kasi minsan maraming ang abogado para sa isang kliyente lamang, so isang counsel lamang daw doon ang pwedeng mag-argue. Section 3, no hearing or oral argument for motions. Motions shall not be set for hearing, and unless the court otherwise directs, no hearing or oral argument shall be allowed in support thereof. Tandaan natin sa bagong rules, Friday na lang yung mga motion na yan, motion day. The adverse party may file objections to the motion within 5 days from service, upon the expiration of which such motion shall be deemed submitted for resolution. Kasi ang motions po ay nire-resolve din ng korte. Yun po. Hindi lamang po yung buong kaso per se, kundi yung mga motion for ganito, i-resolve ng korte whether pagbibigyan ba o hindi. Magtungo na tayo sa Rule 50, ang ating huling rule ngayong gabi. Dismissal of appeal. Section 1, ground or on that of the appellee on the following grounds. Failure of the record on appeal to show on its face that the appeal was taken within the period fixed by these rules. B. Failure to file the notice of appeal or the record on appeal within the period prescribed by these rules. Letter C. Failure of the appellant to pay the docket and other lawful fees as provided in Section 5, Rule 40, and Section 4 of Rule 41. D. Unauthorized alterations, mga hindi pinapayagang alteration o mga tinanggal, may omissions or additions, may dinagdag in the approved record on appeal as provided in Section 4 of Rule 44. Letter E. Failure of the appellant to serve and file the required number of copies of his brief or memorandum within the time provided by these rules. Letter F. Absence of specific assignment of errors in the appellant's brief or of page references to the record as required in Section 13, paragraphs A, C, D, and F of Rule 44. Letter G. Failure of the appellant to take the necessary steps for the correction or completion of the record within the time limited by the court in its order. Letter H, failure of the appellant to appear at the preliminary conference under Rule 48 or to comply with orders, circulars, or directives of the court without justifiable cause. And letter I, the fact that the order or judgment appealed from is not appealable. Not appealable. Section 2, dismissal of improper appeal to the Court of Appeals. An appeal under Rule 41 taken from the Regional Trial Court to the Court of Appeals, raising only questions of law, shall be dismissed. Issues purely of law not being reviewable by said court. Pag daw nag-raise ka ng appeal ng raising only questions of law, ito daw ay madidismiss. Issues purely of law not being reviewable by said court. Hindi daw nire-review ang questions of law ng Court of Appeals. Parang ano nga yata yan, no? Yung petition for yung certiorari under Rule 45, parang yun yung appeal sa Supreme Court. Yung questions of law ay nire-review ng Supreme Court. Yun yata yun, ha? Kung tama yung pagkakaalala ko sa mga binabasa natin. Similarly daw, an appeal by notice of appeal instead of by petition for review from the appellate judgment of a regional trial court may be dismissed. So, yung yun, okay. Ulitin natin. Similarly, an appeal by notice of appeal instead of by petition for review from the appellate judgment of a regional trial court. Ibig sabihin nun, nagdesisyon yung regional trial court through its appellate capabilities. Charot. Galing MTC, umapila sa RTC. Nagdesisyon si RTC ngayon. Yung desisyon na yon dapat by petition for review daw at hindi, at kung ang ginamit mo ay appeal by notice of appeal, ito raw ay madidismiss. Okay? An appeal erroneously taken to the Court of Appeals shall not be transferred to the appropriate court but shall be dismissed outright. Section 3, withdrawal of appeal. An appeal may be withdrawn as of right at any time daw before the filing of the appellee's brief. Kumbaga, yung pinag-uusapan natin last time, plaintiff ako yung nagsimula ng kaso, may problema ako sa'yo, nag-file ako ng aking pleading. So, pwede mo kasing i-withdraw yung iyong kaso bago pa sumagot itong nag-file ng answer yung respondent. Similar din yun ang konsepto sa appeal. Yun daw appeal mo, mari ako, ikaw, nag-apila ka, nanalo ako, ayaw mo yung panalo ko, nag-apila ka. Pwede mong i-withdraw yung appeal mo bago pa ako sumagot. Kasi nung nag-apila ka, ikaw na yung petitioner, ako na yung respondent. Ikaw yung appellant, ako na yung appellee. Ang katumbas ko, respondent. Ako yung sumasagot sa'yo, ikaw yung appellant, ikaw yung nag-aapila. Pwede mong i-withdraw yung iyong appeal habang hindi pa nakakasagot si appellee. Okay? Thereafter, the withdrawal may be allowed in the discretion of the court. So, dyan po nagtatapos yung Rule 41 to 50 ng Civil Procedure. Sana po ay marami kayong natutunan. Ako po ay meron ako mga natutunan sa aking pagbabasa kahit papano. At ina-encourage po natin yung mga legal experts at yung mga lawyers kung may makapapanood nito na makapag-comment at makapagdagdag sa ating comment section. At muli kong pinapaalalahanan, tanging sa mga lisensyadong abogado lamang kumonsulta, ang mga hindi po bar passer o yung mga walang lisensya na mga nagbabasa-basa ng abogado ng batas na katulad ko ay hindi po dapat kinukonsultahan. Magkonsulta lamang po sa mga lisensyadong abogado. Muli po, ito po si Lolo Ray. God bless you and balik tayo sa susunod. 51, Rule 51 to 60. Tapusin natin lahat ng mga libro-libro o internet books na pwede nating mabasa. Basahin natin. God bless you at stay safe.